would be important. The police officer may reduce into writing any statement made to him in the course of an examination under this section. And if he does so, he shall make a separate and true record of the statement of each such person whose statement he records. That question he has to put. That is under 161(1). Then, my lord, he must truly record it. Now, my lord, let us see how he has recorded. May I just request your lordship to kindly turn to page 13 of the charge sheet which I have filed on 17th of March 2022.
Well, happy. Charge sheet act.
Along with my memo, I placed it entire 17th.
ಅಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ಒಂದೊಂದು ಅಕ್ಷರನಾದ್ರೂ ವ್ಯತ್ಯಾಸ ಬೇಡ ಒಂದು ಸ್ವಲ್ಪ. ಎಲ್ಲರೂ ಅದೇ ತರ ಹೇಳ್ತಾರ ಮಕ್ಕಳು ಪ್ರತಿಯೊಬ್ಬರು. ನಾನು ಮೇಲ್ಕಂಡು ಅಲ್ಲಿಂದ ಶುರು ಆಗ್ಬಿಡುತ್ತೆ. Doesn't matter. My lord, may I just request your lordship to kindly turn to page 13.
ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ?
13.
ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ? ವಾಟ್ ಇಸ್ ದಿಸ್?
I'll give it.
ಕೊಡಿ.
ನಮ್ಮ ಹತ್ರ ಇದೆ. ಕೊಡಿ. ಜಗದೀಶ್
ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಹತ್ರ ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಇಲ್ಲ.
ಅವ್ರಿಗೆ ಯಾತಕ್ಕೆ ಅಂದ್ರೆ ಪ್ರಾಬಲಿ he would have conceded ಅದಕ್ಕೋಸ್ಕರ ಇಟ್ಕೊಂಡಿಲ್ಲ ಅಷ್ಟೇ.
ಆತರ
ನಾನು he is
SPP is very fair.
he is very fair. I know him.
Definitely he
Very
will.
fair, very fair. My lord, would your lordship kindly turn to page 13, first witness.
1-3.
Yes.
First
paragraph, ಒಂದೊಂದು ಸೆಂಟೆನ್ಸ್ ಓದ್ಕೊಂಡು ಹೋಗ್ತೀನಿ ಜಾಸ್ತಿ. I will not disturb you, lord. ನಾನು ಮೇಲೆ ವಿಳಾಸದಲ್ಲಿ ನನ್ನ ತಂದೆ ಅಚ್ಚಾಯಿ. Second witness, kindly go to page 19.
ಸೈಕ್ಲೋ ಸ್ಟೈಲ್ ಎಲ್ಲ.
ಸೈಕ್ಲೋ ಸ್ಟೈಲ್ ಆಯ್ತಾ? Now, my lord, forget about all those things. Let us talk of the incident itself. ಇನ್ಸಿಡೆಂಟ್ಗೆ ಒಂದೊಂದು ಮಗು ಬಾಯಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪನಾದ್ರೂ ವ್ಯತ್ಯಾಸ ಇರುತ್ತಲ್ಲ. ಅಟ್ಲೀಸ್ಟ್ now kindly go to the last paragraph at page 13 and onwards. That is the last paragraph. ಸ್ವಲ್ಪ ಸಮಯದ ನಂತರ ಅಂಕಲ್ ನನ್ನ ಹಿಂದಿನಿಂದ ಬಂದು ನನ್ನ ಬಟ್ಟೆ ಮೇಲಿಂದ ಮುಟ್ಟಿದ್ರು. ಆಗ ನಾನು ಯಾರೋ ಮಕ್ಕಳು ನನ್ನ ಹಿಂದಿನಿಂದ ಹೋಗುವಾಗ ಟಚ್ ಆಗಿದೆ ಎಂದು ಸುಮ್ಮನಾದನು. ಅಂಕಲ್ ಮುಟ್ಟಿದ್ರು ಎಕ್ಸೆಟ್ರಾ. ಬರ್ಡೇ ಪಾರ್ಟಿ. Now the next witness, madam. Same. Verbatim reproduction or carbon copy of the statement of one witness. ಎಲ್ಲರಲ್ಲೂ ಅದೇನಾ? Is it in keeping with the mandate of law as mandated under 161(1) and 161(3)? Truly record. Otherwise, my lord, what happens? He can prepare for himself because he does not need his the signature of the witness. Trust this statement as evidence, acceptable evidence at this point of time, unless and until it is put to test during trial. My lord, your lordship may recall to your lordship's memory. Time and again, I would be making the submission. What Justice Chagla had said. Justice Chagla, in one of the judgments which he wrote, my lord, that was a case of dacoity. With a policeman in their armory have two weapons. One is section 161 of the CRPC.
Yes.
And the other is section 27 of the Evidence Act.
Yes.
161 CRPC.
Corroborative material.
No right and anything and everything.
Yes.
Keep it
And
on
take
as
recourse to
acceptable
27.
evidence. Then under section 27 of the Evidence Act, no, record the statement to the accused saying that if I am taken, I will take you to the such and such a place where I have hidden the weapon used for the commission of the crime. Well, that would be present to service as evidence. Well, if those two, 161 CRPC and section 27 of the Evidence Act, are removed from the statute, the policeman is just like a snake without a teeth. That is what Justice Chagla had said.
True.
Yeah, same mechanical reproduction.
I saw.
Well, now let us go to. Now kindly go to the POCSO. Well, it is a self-contained code. Investigation is to be done in accordance with the provisions of the POCSO.
Yes.
Quite often your lordship would say, listen until you say POCSO, not as POSCO.
Telugu.
I have pronounced it properly, well, and therefore your lordship
No,
continue to hear me.
Generally, it is done that way. I keep correcting. No, it's POCSO. Postಕೊಳ್ಳೋದಲ್ಲ.
May I request your lordship to kind in good humor, my lord. I
Yes.
say.
Of course, yes.
Sometimes we need humor in court.
Break the monotony.
Court house.
Yes.
But may I just request your lordship to kindly turn to chapter 6.
Of POCSO code.
It is a self-contained code. It leaves no doubt. He has got to investigate in accordance with the provisions of this act. It is a special act. It is a central act
Yes.
where procedure for investigation is prescribed. Well, chapter 6 prescribes the procedure for investigation.
Yes.
Kindly first go to section 24.
Recording of statement of the
Yes, madam.
child.
The statement of the child shall be recorded at the residence of the child or at the place where he usually resides or at the place of his choice and as far as applicable by a woman police officer not below the rank of a sub-inspector. The police officer while recording the statement of the child shall not be in uniform. The police officer making the investigation shall, while examining the child, ensure that at no point of time the child comes in contact with any of the accused persons. That is the procedure that is prescribed under section 24, 1, 2, and 3 subclauses. Now kindly go to section 26 for a second.
Additional provisions.
Yes. Additional provisions regarding the statement to be recorded.
Yes.
The magistrate or the police officer, as the case may be. Well, a magistrate comes into picture when the child is taken before him.
Yes,
Or the
164.
witness, yeah, under 164. But as far as the police officer is concerned, he has got to record the statement as mandated under section
161.
24 of the Act, or my lord, under section
161 of the
161 of
CRPC.
the CRPC. The magistrate or the police officer, as the case may be, shall record the statement as spoken by the child in the presence of the parents of the child or any other person to whom the child has trust or confidence. A plain reading of the statements recorded by the policeman. Well, does it infuse any amount of confidence in your lordship's judicial mind that this statement came to be recorded in the manner spoken to by the child? Well, now kindly go to
Yes.
subclass 4. Wherever possible, the magistrate or the police officer, as the case may be, shall ensure, well, it is mandatory, shall ensure that the statement of the child is also recorded by audio, video, electronic means.
That is crimes against women.
No, my lord.
Oh, in this POCSO.
In
yes.
this POCSO,
No,
my lord.
even 161, if you see,
Yes.
exception is
Yes, yes,
carved
yes.
out in
That is
section
under section
354.
300.
Wherever crimes against women, they should be,
Well,
they
this
can
is
be
under
electronically recorded also.
Why it is so for this reason? Well, it is a protection that is given not only to the child, but also to the accused who is to be prosecuted in the case. Because the child may not be knowing what it has said or not. What did she say? What did he say? Statement of the child is also recorded by audio, video, electronic means. Shall.
What is the medical report?
No, next point is that, Manad. No medical examination at all. Why? Why? No, no, no. Internal injuries irbodu. No. Why I shall submit to your lordship now? There has been a total non-compliance with the mandatory requirement of law as mandated under section 26 of class 4. Well, audio, video. Where is the audio? Where is the video? Nothing. They have taken away the protection that is given to an accused under the provisions of the POCSO. Had it been there, probably your lordship would have been certainly in a position to know whether the child has said so or not.
Because even the 164 statements are cyclostyle.
Cyclostyle.
That is shocking. Even before the magistrate, what the children have said, ella cyclostyle.
The only issue
Repeat.
subject to senior counsel.
ಮುಗಿಸ್ಬಿಡ್ಲಿ that.
Right.
Yes.
Well, now, I think I need not labor much on this point. When law prescribes, my lord,
A thing to be done. Shall be done or not
otherwise
at all.
it
Yes.
will have invalidating consequences. Is law that is being laid down by your lordship time and again, and also by the Honorable Supreme Court. I need not lay down. When once it is a shall, it means it is not directory, it is mandatory. It is mandatory. No, my lord posed a question to me. Where is the medical examination report? May I now invite your lordship's kind attention to section 27 of the Act. Violation after violation.
Medical examination of the child.
The medical examination of a child in respect of whom any offence has been committed under this Act. When you are prosecuting me, when the allegation against me is under section 7, which is made penal under section 8 of the Act, any offence, whether there is injury, no injury, let the doctor say no injury. You can't say that I will not subject myself for medical examination. Adan torstini, carbon copy adannuve. Ellaru idaralla 8 jana, 8 janadu carbon copy. But now here kindly see, in respect of whom any offence has been committed under this Act, shall, notwithstanding that a first information report to the complaint has not been registered for the offences under this act be conducted in accordance with section 164 capital A of the Code of Criminal Procedure. Compulsory, ಮಾಡಲೇಬೇಕು. Violation? Again, invalidating consequences. So why they don't do it? Your lordship could get from my compilation of the charge sheet. May I just request your lordship to kindly turn to well, reading page 57 and onwards. Well, I just now took your lordship to the 161 statements.
Yes.
ಅದರಲ್ಲಿ
ಇದ್ಯಾರ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್?
ಇದು ಇವ್ರು ಬರ್ಕೊಡೋದು ಎಲ್ರದ್ದು ಅದೇ ಒಂದೇ ಕಾರ್ಬನ್ ಕಾಪಿ. ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಬೇಡ ಅಂತ. All would come into existence on 1st of October 2018.
1st of October.
1st of October 2018. ಎಲ್ರದ್ದು ಒಂದೇ ದಿನ. ಏನ್ ಹೇಳ್ತಾರೆ? Reference to your notice dated 1/10/18. ಅವತ್ತೇ I hereby decline medical examination of my daughters, so and so, so and so. They are aged 9 years. They are not been bruised or injured physically. I do not want to cause mental harassment. Next to other, aged 9 years. She has not been bruised and injured physically. I do not want medical examination. Next to, how does each ಗೊತ್ತಾಗಬೇಕು bruise ಇದೆಯಾ ಬೇರೆ ಇಂಜುರಿ ಇದೆಯಾ ಎಲ್ಲರೂ ಒಂದೇನಾ? Every page. Well, this is again a flagrant violation of the mandate of law as mandated under section 27 of the act. This would be my next legal submission. Well, subject to what my lord would ultimately say. Well, no sooner the court takes cognizance of the offence, and within 30 days, that is what the law mandates. The trial court shall record the evidence. May I request your lordship to kindly turn to section 35.
Yes.
The evidence of the child shall be recorded within a period of 30 days of the special court taking cognizance of the offence, and reasons for delay, if any, shall be recorded by the special court.
Yes.
ಏನಿಲ್ಲ. For years together it is getting adjourned.
ಅಲ್ಲ ಇಲ್ಲಿ ಸ್ಟೇ ಮಾಡಿದೀವಲ್ಲ.
ಈಗ ಬಂದಿರೋದು ನಾವು 2022 ನಲ್ಲಿ, ಇದು 2018.
ಅವಾಗಿಂದ ನಡೀತಾನೆ ಇದೆ.
ಅವಾಗಿಂದ ನಡೀತಾನೆ ಇದೆ. This is again violation of section 35.
Yes.
Lord, if my lord is persuaded to accept my submissions, right from the date of taking of cognizance of the offence, that also we do not find. We have to presume that he has taken cognizance of the offence on 17th of December 2018 or 18th of December 2018.
Why, what was the motive behind the
Lord,
complaint?
yes. My lord, it is an apartment
Hmm.
where number of flats are there.
Hmm.
In one floor, 6 flats are there in one floor.
Hmm.
Well, in 2 of the floors, my lord, the informant has been running a PG hostel.
You have objected to it.
I objected to that. And the resultant effect is I am prosecuted. But
Where do you get that pleading is to that effect is there?
leading ಇಲ್ಲ ಫೋಟೋಸ್ ಇದೆ ಅಂತ ಕೊಡ್ತೀನಿ.
Photos.
ಅಲ್ಲ PG ನಡೆಸ್ತಾ ಇರೋದು.
ಅಲ್ಲ ಅದು pleading ಇದೆಯಾ?
ನಾನು ಕೇಳಿದೆ ಅದನ್ನ ಅವತ್ತೇನೆ. ಒಂದು ರೀಡಿಂಗ್ ಬೇಕಾಗಿತ್ತು ಅಂತ ಅವಶ್ಯಕತೆ ಇತ್ತು.
Because finally, if you have to answer motive, it seals. Then we will hear the additional speak.
ಪ್ಲೀಸ್.
Yes, sir.
ಅಲ್ಲ ಇದರಲ್ಲಿ
ಇನ್ಯಾವುದಿದೆ ಸರ್?
ಅಲ್ಲ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಓದ್ಬಿಡ್ತೀನಿ ನೋಡೋಣ ಏನು ಎಲ್ರದ್ದು ಅದೇನೆ.
Which?
Yes. Your lordship may kindly turn to page 80 of my petition,
1880.
80. Typed copy, you will not 82. Does it not defy elementary logic and common sense, my lord?
ಇಷ್ಟೇನಾ?
ಇಷ್ಟೇ, ಏನಿಲ್ಲ, ಒಬ್ಬರಾದ್ಮೇಲೆ ಒಬ್ರು ಬರ್ತಾ ಇದ್ರಂತೆ ಕತ್ಲೆನೆಲ್ಲ ಸಾಲಾಗೆ, ನಾನು ಸ್ಕ್ರೀನ್ ಹಿಂದೆ ನಿಂತ್ಕೊಂಡಿದ್ದಂತೆ ಎಲ್ಲರನ್ನು ಮುಟ್ತಾ ಇದ್ದಂತೆ ಇನ್ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಆಗಿ. I can understand one, I can understand two, not all. And next day complaint.
Who is the complainant?
Well, the complainant is the father
Of
of one of the child.
one of the child.
Yes,
Speaking for every child there.
he speaks for every child.
Hmm. And where is the charge sheet?
I'm sorry, madam.
Charge sheet
Yes, your lordship will get the charge sheet.
31,
30?
1.
I have given the full set of the charge
Yes,
sheet along
yes.
with the memo, my lord. This column number 7, it commences at page 31, my lord. 31,
Yes.
column number 7.
And it is continued at 35.
Yes, it continues at page
35.
35. 25 ಮಕ್ಕಳು ತಗೊಂಡಿದ್ದು.
Yes, sir.
The issue of taking cognizance, my lord, the record says perused. With respect to non-furnishing of document, medical report, FSL report, it was not there. So therefore, the court may have sought for it if it is there. Your lordship may see that the charge sheet itself says that medical report is not there. Therefore, FSL report is also, it cannot be a.
Well, medical report ilve illa, examination ಆಗಿಲ್ಲ, what report?
Therefore, though the court said, my lord, probably it mechanically sought for a report in case, since it was absent in the charge sheet, probably mechanically they sought it, my lord, but it has no consequence of present case in hand. Because what is required in this case is only the statements and the 164 statement recorded during the course of
ಇಲ್ಲ
investigation.
cyclist right. 164 statement to cyclist.
Your lordship may see the incident. It's not that incident happened at multiple locations. Incident happened at one place
One location.
and one time. So action is that he is touched them inappropriately at wherever this thing.
That is what the complaint says.
The correct, my lord. So that is what 161 statement, I can understand, my lord, 161 statement is verbatim as senior counsel has read out it. 164 statement.
Even that is verbatim. Nodi,
I've seen that.
see,
Yes,
even that is the same.
but the fact that, my lord, at least
That is
there is
precisely why I saw the 164 statement
my lord,
also. Nodi ನೀವು.
English, Kannada ಎರಡು ಇದೆ.
ಅದು English ಅಲ್ಲಿ ಇರೋದೇ ನೋಡಿ.
ಎಲ್ಲರಲ್ಲೂ it's
ಎರಡು
similar.
ಒಂದೇನೆ.
ಹೌದು. The issue is that he has touched them when they were playing. So if it is in a different location, if it is a different victim, a different time zone, this we could have said it, my lord, it maybe some
What
doubt.
do you say about gross procedural violations?
With respect to that, my lord, there is they are not, ultimately he can take benefit of those things if it is against this thing. The only issue
In a
is
trial.
wherever it is provided,
In a trial.
wherever it is provided shall. It is not necessary, of course, it's mandatory, but
No,
wherever it
that-
is provided.
It's wholly penal. It should be, even if it is may, it should be read as shall only.
That language also used, my lord, wherever it is provided. So therefore, it is not that, of course, he can take the benefit if it is not been done during the course of trial. But at this stage, my lord, when evidence has been begun, charges have been framed, of course, there is an issue with.
Is that the way to frame charge?
Uh.
What happens to 227, 228? All those procedures